Good morning, everyone. I would like to extend a very warm welcome to everyone present in this webinar. Thank you for joining us today. My name is Macklin Pereira, and I'm a corporate paralegal at Fishthe & Co. Legal Consultants. It is my pleasure to moderate today's webinar on special purpose vehicles and special purpose acquisition companies under the new Commercial Companies Law. Today's webinar will discuss about the introduction of SPVs and SPACs as corporate forms under the new Commercial Companies Law and will be presented by our Corporate of Counsel, Dr. Laura Voda. The webinar will be for a duration of 2 hours with a 15-minute break at 10:45 a.m. It will entail discussions on these corporate forms with the following agenda. The presentation will be divided into 5 sections, starting with an introduction to SPVs and SPACs, and further moving on to the definition of SPV and SPAC with its legal implications. The third and fourth section concentrate on more practical aspects, including the considerations and functioning of the new structures, followed by the legal risks and liabilities involved, substantiated with case studies. Finally, we will close the presentation with concluding remarks by Dr. Laura. I am confident that participants will benefit greatly from the insight provided by Dr. Laura. Upon conclusion of the presentation, we will be holding a 20-minute Q&A session to answer any queries sent by the attendees. In order for attendees to ask their questions, an icon in the shape of a question mark will be visible at the top right corner of your screen, which will lead you to the Q&A chat box where you may submit your questions. Please note that this question box will be accessible at all times, even during the presentation. However, the questions will only be published and answered during our Q&A segment after the completion of the presentation. Moreover, depending on the number of questions we receive, we will aim to our best ability to respond to as many of your queries as we can within the time frame that we have for the Q&A segment. Now, without any further delay, if I may pass on the screen to Dr. Laura Voda. Thank you.
Good morning, everybody. Thank you for being here. It's nice to see you all again. It is fortunate that we have today quite a number of participants in our session, in our webinar. We thought to address this webinar for both professionals that work in the corporate field, as well as for the professionals that are more accustomed with the capital markets or with the financial markets in general. It is quite interesting, and it's quite a good development that structures similar to, let's say, leverage buyouts in the financial markets have been made possible in the UAE, with the sole difference that in a leverage buyout, for instance, the funds are borrowed, whereas in the structures that we have on the agenda today, the funds are raised from the public market under the supervision of a regulator. As said, we have for now included this discussion in the overall developments that have been made possible in the market in the beginning of 2022, meaning the overhaul in the Commercial Companies Law. So for today, we have prepared an agenda that includes a number of topics, introduction to these new developments, how do we position these developments into the overall market and into the possibility to streamline capital coming into the UAE. Why did these structures occur? And finally, few case studies, few examples on how successful they have become post-COVID-19. COVID-19 had actually a role in benchmarking these structures and in making them, let's say, more attractive for PE markets worldwide. Moving forward, yeah, we need to start with the developments that have been introduced by the Commercial Companies Law. In this particular respect, yeah, I would need to emphasize the role of law number 32 of 2021 in force as of 2022 that has replaced the Commercial Companies Law in its previous version, Federal Law number 2 of 2016, and its amendment decree 26 of 2020. Obviously, these developments have been much anticipated, um, provided that they have, let's say, introduced quite a good hedge for the growth of the companies existing into the market, quite a good hedge for foreign investors in acquiring 100% of the ownership of a company, quite a better protection for foreign investors, etc. This law, as said, comes with the buffer period of 1 year for the changes to be implemented. However, for the structures that we have on the agenda today, the framework is already in place, and we will discuss about it right away. Moving forward, we have set to place these developments in a requirement of context. We see that the law provides more fluid, let's say, provisions, making the growth of the companies that exist in the UAE more certain, structures, less dependent on bureaucracy, less dependent on corporate regulators, with a very, let's say, clear statutory provisions that would support their function. If we look, for example, into the growth of limited liability companies that exist in the UAE, the changes are massive. Of course, public companies and companies that originate in the governmental sectors are going to be exempt from the growth of the application of these Commercial Companies Law. However, for instance, nowadays the statutory reserves have been decreased, allowing the companies, let's say, to keep and possibly to reinvest as much as capital as possible. Moving forward, we would say that there's a clearer and simpler procedure for convoking a General Assembly meeting. The quorum for participating in a General Assembly meeting has actually changed because nowadays in the new law, yeah, the quorum required for attending a General Assembly meeting, yeah, if not met at the first encounter, would be definitely, let's say, make a new General Assembly meeting to pass, irrespective of the number of shareholders present. So in this context, the new Commercial Companies Law creates the hedge that we are discussing about in order to streamline income generators into the UAE. And now moving forward to the main topic that we have on the agenda today is the introduction of new corporate structures. We would need to note that the UAE is the first jurisdiction in the region that introduces this kind of structures, and ADX, Abu Dhabi Securities Exchange, is the first stock exchange in the region that actually issues regulation for listing joint stock structures as introduced by the new Commercial Companies Law. Moving forward, the introduction of these new structures, Spvs and SPACs or SPACs, as they are being known in the capital market, is not, let's say, a legal innovation. These structures do exist and have existed in a number of jurisdictions. However, they became quite popular in the COVID time. It's not random that, for instance, the time when the Commercial Companies Law entered into effect in 2022, and the SCA, the Securities and Commodities Authority, has issued a certain number of regulations on these SPVs. Yeah, other corporate regulators in the world publish their consultation papers willing to introduce the same. We discuss here about, for instance, Hong Kong, who at the same time with the UAE has passed their consultation paper in order to allow these investment vehicles to be existing and well promoted into the market. Now, moving forward, how does the law regulate, or how does the law define SPVs and special purpose acquisition companies, or SPACs? Now, the special purpose acquisition companies are not different than what exists in other jurisdictions. For example, in US, where they originate, they are generally called blank check companies. In the realm of the new commercial companies law, these are being defined as public joint stock companies that have a sole purpose to acquire capital from various investors and further be used in a merger and acquisition transaction called de-SPAC transaction. The SPVs, the special purpose vehicles, are also companies that exist in the realm of a financial regulator, which is the SCA in this particular case, and their purpose is to actually isolate liabilities and separate the assets and obligations of an investor with the assets and obligations of a, let's say, of the company. With this particular respect, let's say something is happening with the investor, and obviously the assets and liabilities of the SPVs will not be affected. And correlatively, if let's say the investment is related or linked with a governmental authority, yeah, the investment structure would not be affected irrespective of a change of administration and the like. The law mentions also in Article 4, the new commercial companies law mentions also in Article 4, that these specific structures are essentially regulated by the SCA, and they are exempt from the application of the commercial companies law insofar as the changes at issue have been already regulated by the SCA. And we will see immediately that the SCA has actually issued a regulation in respect of SPACs, this making, let's say, these structures unique, innovative, and quite, let's say, welcomed in the UAE market. Now, if we look into the business prospectus in here and how the market is opening, obviously the jurisdiction has attempted over the years to develop a certain number of, let's say, incubators, a certain, let's say, incentivized types of companies that would potentially in the future create the potential of being monetized. With this kind of structures, it's possible to acquire, let's say, a tech or a pharma company from UAE with an acquisition vehicle incorporated in UAE. Prior to the entry into force of this new law, this process was not possible. Because if, let's say, a large tech was to be acquired or to go public in UAE, this was being usually done through an investment vehicle registered and regulated in the US. Because in here, we wouldn't have, let's say, the necessary legal framework in order to incorporate and operate this kind of structure. Similarly, if, let's say, a professional investor from here, or let's say a sovereign fund from here was to invest abroad, this was also done through an SPAC or through a SPAC which was registered abroad. Now, moving forward, in simple terms, what are these SPVs and these SPACs? They have quite few simple features that exist in each and every jurisdiction where they are regulated. I would say that most importantly, we need to stress out that business hubs worldwide do have this kind of structures. US has them, the European Union has them, Singapore has them, now Hong Kong has them. Therefore, it is pretty much, let's say, foreseeable that the UAE has the same aim of regulating these structures and making them, let's say, more and more convenient as investment vehicles for the future. So basically, as we were saying, and it's clear from the definition of an SPV under the Commercial Companies Law, the sole purpose of an SPV is to separate assets and liabilities from the ones of the company. And obviously, this kind of structure has a certain hedge, because various liabilities that appear at the investor level would not affect the investment in this SPV and vice versa. We would estimate that, let's say, SPVs would be extremely useful in financial restructuring, corporate restructuring as well. However, one needs not to confuse the SPV as a regulated entity with the term SPV that exists and is used generally in the business world today. The SPVs, as regulated, are about gathering large amounts of funds from a number of investors. Yeah, we've seen, let's say, the majority of the market operating with so-called SPVs as non-regulated entities, gathering investments from 2, 3, 5 investors. This is not what these regulated SPVs is about. It's about creating a certain financial and legal leverage for the specific, let's say, investors to put money in a structure where their liabilities, assets are separated, therefore protected, where the purpose of that investment is clear and straightforward. Now, we do have in the UAE the prescribed companies and several exempt companies in the ADGM that would, let's say, look akin the SPV. However, from the point of view of their main regulator, the SDA, further developments are being expected in order to address the way the function per se and the procedure of, let's say, putting them into various commercial structures. What is very interesting to see is that nowadays the changes that have been introduced by the commercial companies law into the public joint stock entities, which are not small, actually create the possibility that a public joint stock is divided both vertically and horizontally. In this perspective, yeah, we believe that these structures have been created for the sole purpose of being included therein into these structures and to be able to separate assets and liabilities there too. Now, moving to the second type of vehicle that has been created, the SPAC, SPAC. Yeah, the special purpose acquisition company, also called blank check company, is nothing more, nothing less but a shell company. It is a public joint stock which has the purpose of acquiring, gathering funds, doesn't have commercial operations per se. Yeah, they only issue an IPO for the purpose of using the funds so acquired into a merger and acquisition transaction at a later stage. And then obviously one may ask themselves, okay, if it is a shell company, how does it function overall? And how it is different from a traditional IPO. We know, and the professionals that have contact with the capital markets, they know that the traditional form of going public involves the company at issue that wishes to go public to go through a process of valuation. There may be an investment bank, let's say, involved. The company is very much exposed to certain volatile variables that may exist in the market at a given time. Therefore, before reaching the IPO, yeah, there is a real possibility that the business prospectus that has been envisaged by the shareholders or by the authors of the IPO at the beginning of the process not to match with what is offered finally. And it is very possible that the company loses value and the investors lose interest as well as money. Going public with a traditional IPO takes a considerable amount of time, whereas in order to address this situation, the SPACs make things much easier, because the SPAC is a newly incorporated structure. It is very much linked with the experience, background, knowledge of its sponsors. Yeah, and then when the company is being regulated, registered as a SPAC, it already launches an IPO, gathers funds through this IPO, post gathering funds and adding them into, let's say, an escrow account. Yeah, the investors would come to know where, yeah, or which is the target entity that the SPAC is going to merge with. Normally, and in most jurisdictions, yeah, the time frame for finding this target and merging with it is within 2 years from the IPO. In Hong Kong is, for example, 3 years. The deadlines are similar in the UAE, which, with regards to the SPAC, seems to have adopted more the American point of view rather than the European point of view in the legislative process. Now, moving forward, we know that SPACs have existed into the market since the 90s. Their history is not, let's say, the most lenient one, and we would say that a lot of business scams have been associated with these investment vehicles. Things have changed quite a lot. We have studied a few statistics, and then for the SPACs originating in the US market for the period 2015 to 2019, the statistics show that half of them have performed. A few, let's say, of them have entered into liquidation for various reasons. One of these reasons is not finding the target to merge with post issuing this IPO. And some of them are still probably in process of finding and merging with the specific target and completing the de-SPAC transaction. But what we have also observed and what is actually shown in the slide is that in 2020, these kind of structures registered a boom. And it's a market that entailed at the time around 80 billion US dollars. And then it is very visible from the chart that we have presented, which is not ours, but we copied it with permission. It's very visible that a huge increase in the popularity of this structure happened in between the first and second trimester of 2020. Now, if we look into the historical event, this corresponds to the lockdown period post COVID-19. And then we were saying in one of our previous webinars at that time that is expecting that the private equity markets and the capital markets in general to grow. This kind of structures, the SPACs, are regulated entities. They are public joint stocks. They provide, let's say, a certain security for the investor in comparison to a traditional non-regulated company. Therefore, at that time where the markets tend to become volatile, exposed to a lot of, let's say, events that were out of the control of the investors, this vehicle proved to be quite a good alternative for let's say, investing the larger amounts of capital. It is quite interesting to see this phenomena. And then the largest transactions that have been operated around that time happened in the SPAC sector, and we have provided a couple of examples here. They originate in the US market because the US market is very visible when it comes to these investment vehicles. We have a couple of good examples from Europe as well. Amsterdam Stock Exchange appearing to take the lead in listing this kind of companies, followed by the Frankfurt Stock Exchange. But then we would refer to an example which is, let's say, very well known, very well marketed to all of us, which is the Virgin Galactic. Virgin Galactic is actually the first commercial space flight vehicles company that is operated with public funds through a SPAC. This SPAC originates in social capital hub Sofia Holdings, who raised around 800 million US dollars for Virgin. Their website can be checked. The information is publicly available. And then we have today Virgin Galactic Holdings. The merger has been completed. The transactions have been successful. The investors, the ones who did not redeem their shares, are happily part of this holding. And then obviously participate in the growth of, let's say, one of the most successful ventures recorded in the recent history. Other similar transactions have been recorded with, let's say, other digital platforms, healthcare and pharma institutions, and then probably the most successful, I would say, as volume of gatherings have been Pershing Holdings in 2020 that managed to gather around 4 billion US from or as a result of an IPO originating in a special purpose acquisition company. Therefore, there is a huge interest in these special purpose acquisition companies. They seem to be the new, let's say, form of I would say, crowdfunding, if this is possible. And then in this realm, which tends to be very favorable, the regulators in UAE have decided to move into the same sphere and make these structures possible here in the market. Now, moving forward, we have a legal regime for SPACs that originate in 2 or I would say 3 legal instruments overall. It's number 1, the Commercial Companies Law. Number 2 is the decision of the SCA Board of Directors, number 1 of 2022, who is in force as of January 14, 2022. And we also have the listing rules of Abu Dhabi Securities Exchange, ATX, which, as said, is the first, let's say, the first exchange in the region that has published rules for listing this kind of structure. It's quite interesting to see how things came hand in hand and how the UAE actually managed to keep track with developments that happen in other jurisdictions known as significant business hubs. As we were saying, the UAE published this SCA Board of Directors rules at the same time with, let's say, the entry into force of the Hong Kong rules on similar structures. What is specific to the regulation in UAE? Obviously, there's a lot of, let's say, operational insight that the SCA Board of Directors decision brings into the picture. We have tried to bring in, I'd say, the most important ones, the ones that appear fast, and the ones that we can approach within the short time frame that we have with this webinar. Now, looking at a simple view of a SPAC, it is quite important for somebody to respond properly to the question, okay, how do I invest in a SPAC? Or what is important for me to know whilst investing in a SPAC? The lawyers who work in capital markets, it's very possible to have received these kind of questions from their investors, from their clients. And one question that comes to us quite often is that if SPAC structures in UAE are going to be offered to the retail investors. According to the SCA Board of Directors decision of 2022, it appears that yes, but the conditions and offerings would, let's say, remain to be seen in the close future. ADX at the same time has or is listing a number of structures that have a lot of retail investors, and we look into Etisalat or FAB. At the same time, ADX attracts quite a number of global institutional investors, and we would note here Vanguard, BlackRock, JP Morgan Chase, etc. So basically, I believe that retail investors can be somehow included into this kind of structures in the close future. However, these elements would be seen as we go. We don't have a precedent to refer to there too. Now moving on, what would I respond to my client if asked how do I invest in a SPAC? The response is very simple. The SPAC is a joint stock, it's a public joint stock, it's a regulated entity, quite, let's say, certain in its way of functioning, in its internal kitchen, that doesn't have commercial operations per se. It only acquires money, yeah, and then through initial public offering, and uses this money to be reinvested, to be merged, yeah, with an already existing entity. It provides benefits for both sides, because for the investor, yeah, the value of shares may appreciate, whereas for the company that is being merged with the SPAC, yeah, it goes public. It has access to larger amounts of capital. It would be listed on a stock exchange. Therefore, its commercial operations, its funding, its value, its market value, its equity would increase if, of course, everything goes well and the market conditions are favorable to that particular transaction. Now, moving forward, what moves the investor, or what guarantees to the investor that their, let's say, placement of funds is actually secure? As said in the beginning, these kind of structures are initially formed by sponsors, founders, their management structure. The management structure is composed of individuals who actually come into the picture with a specific background, with a specific reputation, with a specific experience, with a, let's say, a non-conflicting past, with, let's say, approval that are issued by the SCA, because the founder, the sponsor of a SPAC needs to be an individual or a group of individuals that have the approval of the SCA. If we look into, let's say, similar regulations in Hong Kong, for instance, that came into effect around about the same time, yeah. In Hong Kong, let's say, there are classes of approvals that the regulator is issuing for the persons that can act as sponsors, as directors in a SPAC. And then the question that somebody may receive from a client is, okay, but how do these people make money, right? And then it is very important to clarify to them that the funds that are being placed in a SPAC are not being taken by the sponsors. They are being escrow, they are being placed in an escrow. And in our case, this escrow is or needs to be an independent party that needs to have the approval of the SCA. And then the UAE makes no difference in comparison to other jurisdictions, because all SPACs, all these kind of structures have public floating requirements. Normally, the sponsors of a SPAC acquire money from a promote. That's how it's called. Simply put, they obtain their, let's say, return of investment post completing this SPAC transaction in the form of a promote, which is a certain leverage or a certain threshold of shares that they can acquire at a discounted rate. For example, if we look into the Virgin Galactic structure, which is very marketed, very well known worldwide, the sponsors were able to acquire their promote at a discounted rate of 0.004 USD per share in comparison to the IPO value that has been, let's say, paid by the investors, which was of $10 per share. And then in the UAE, the threshold approach is the same. It is regulated in the SCA Board of Directors decision of 2022, and this promote must be not less than 100,000 dirhams pre-IPO, and in between 3% and maximum 20% of the SPAC issued shares post-IPO at the time of the SPAC transaction. So these limits do exist, and they constitute a guarantee for the investors that their amounts or their investment is not going to be diminished by the activity of these sponsors, of these leaders of the SPAC that finally move the entity towards this SPAC transaction towards its final purpose or its final aim. That's quite interesting. And then moving forward, one may ask, obviously, a very natural, very normal question. How do we establish a special purpose acquisition company? We have detailed the procedure in the next slides. However, the minimum investment required is 100,000 dirhams as initial capital before the IPO, on the condition that the market capitalization post IPO reaches at least 100 million United Arab Emirates dirhams, and then which is I'd say lower than in other jurisdictions. In US dollars is around 27, 28 million, in euros a little bit less. Then moving forward, all the amounts that are being placed in a SPAC by the investor would need to be escrowed. As said, maximum 10% is allowed in UAE of the funds that are placed in a SPAC by the investors not being kept in escrow. The conditions of escrow, the escrow entity would definitely need to be approved by the SCA, and this escrow needs to provide the full guarantees of independence for receiving these amounts that are being placed by the investors in a special purpose acquisition company. As said in the beginning, the SPACs are public joint stock companies. However, one may not assume that all the rules and regulations applicable to a normal joint stock company applies to them. Public offerings, the promote, the procedures for capital increase, conversion of companies like the de-SPAC transaction, the M&A rules, the subscription rules are different in a SPAC rather than a normal public joint stock company. What is interesting also about these structures is that at the moment that the de-SPAC transaction is being completed and the target has been acquired, merged with the SPAC, the newly formed structure is indeed a public joint stock company, but is not a SPAC. Therefore, post the de-SPAC transaction, the newly incorporated entity, the newly formed entity, I would say, would become subject to the provisions for public joint stock companies as they currently exist in the Commercial Companies Law. And towards the end of this presentation, we are going to refer to these rules that have changed inclusively for the joint stock companies per se. Now moving forward, what is the procedure, or how is it possible to incorporate a special purpose acquisition company in UAE according to these new rules as set up by the SDA Board of Directors rules of 2022. Procedure is very simple. it all starts with an application that is made to the Securities and Commodities Authority, to the SCA. This SCA application would need to include the full background of the sponsors. I said the role of sponsors, these mandatory appointments are extremely important, because they are the ones that lead and have the knowledge, the know-how to make this kind of transaction successful. And then the Securities and Commodities Authority, within 10 days of receiving this application, 10 business days, would need to give their consent as to whether they agree or not to register a specific company as SPAC or as another regulated structure. Provided that the SCA has issued their consent for an entity to be registered as a SPAC, one application needs to be made to a commercial registry, to a corporate regulator, in order to obtain a license of that newly incorporated structure. The licensing process is happening through the governmental entities affiliated to the Ministry of Economy in each and every emirate. And then once this application has been completed, the corporate regulator is going to issue a license for the newly registered entity, the SPAC. Now, moving forward, the new step that the applicant needs to complete, prior to going public, is to obtain from the Securities and Commodities Authority a pre-IPO approval. What is happening at that time? The applicant needs to submit to the SCA a business plan, the modality of investment, a detailed, let's say, prospectus of that particular investment, what strategy exists, how, let's say, or what kind of protection is issued to the investors in a SPAC. And then once all these boxes are being ticked, and once, let's say, the SCA is convinced, that the SPAC as registered has, let's say, real chances to succeed, would issue this pre-IPO approval. However, if, let's say, the documents are not met as to the satisfaction of the SCA, or the failure to submit of the necessary documents thereto would lead in or may result in the liquidation of the SPAC. It's quite interesting that the SCA takes an active role and places this environment of investments in a fully, let's say, regulated spectrum, in order to protect both the input and the output of this kind of transaction. Obviously, what is very important to know in a SPAC transaction is that the business target, the entity that, let's say, the SPAC is willing to acquire post IPO, would not be disclosed prior to making this IPO. So at the time of the IPO, only the sponsors of this SPAC are being aware of the target or of the prospectus of acquiring the specific target in the future. Now I believe that it's 10:45. It's time to take a short break at 10-15 minutes. I'd say that we meet at 11 a.m. And we continue with the discussion for today. Thank you for being here, and see you in quite a short time. Good morning again for the second part of our meeting today. I hope that you have found the first part of our presentation useful, and we have for the second part of it kept few important information that you would probably need to look into as corporate or capital markets professionals. For now, we have discussed how to register a SPAC with the corporate regulator, respectively with the SCA, with the Securities Commodities authority. And then finally, post-registration of this SPAC would need to do an IPO, an initial public offering. The purpose of the IPO is, as said, to acquire funds according to the market capitalization rules in UAE, 100 million dirhams at a minimum, in order to have them used after that for the SPAC transaction, for the M&A transaction. And moving forward, the IPO rules, as described in the SCA Board of Directors decision of 2022, are as follows. The first step prior to an IPO is the filing of this IPO prospectus with the Securities and Commodities Authority. This prospectus would need to be made available to the public minimum of 3 business days prior to the commencement of the subscription period. And then the invitation to subscribe to the IPO would be published in 2 local newspapers, including an Arabic language newspaper. Prior to such approvals being obtained and prior to, let's say, this notice on the IPO being given to the general public, the subscription period, or the period in which the investors are required to place their funds to subscribe to the SPAC, is of in between 5 and 30 business days from the date of this notice, unless an extension is being obviously granted by the SCA. To add more security to the investors, all the funds that are being subscribed in a SPAC would need to be placed in escrow within maximum 2 business days of their receipt, under the conditions that we have earlier stated, that the escrow needs to be approved by the SCA, as long as together with the rules of this kind of placement. When all these procedures are being successfully completed, the last step prior to listing is actually the issuance of a registration certificate by the SCA. Now, obviously, it's the sponsors, the directors of the SCA that would apply for this registration certificate and paying the fees to the SCA. And then post issuance of this certificate of registration, the SPAC would need to apply to the exchange, ADX in this particular case, in order for the shares and the warrants of the SPAC to be listed on the stock exchange. Now, shares and warrants are listed separately. Shares, I believe it's quite simple. They are shares of a nominal value. In UAE, it's in between 1 and 100 dirhams per piece. But then warrants are contractual agreements made to the investors according to which they would be able to acquire stock in a specific period of time in a locked-in price, I would say. So with this procedure for the IPO, or post its completion, the SPAC can go public, its shares are public, and then obviously we can move towards the last part of a SPAC-related transaction, which is the de-SPAC or the merger and acquisition transaction. Now, what is happening within this period? So the investors have subscribed, they have acquired their shares, they have placed, let's say, funds in the public joint stock entity, which is now listed on the stock exchange. And then within, let's say, a specific time frame, in UAE, the SCA Board of Directors rules mention the following procedure, which is actually in line with the American approach. Within the time limit that is proposed in the IPO prospectus, or in the maximum 24 months of the IPO, the target needs to be identified, and the de-SPAC transaction would need to be completed. The 24 months, the 2 years period is quite regular. We have encountered this deadline in the majority of the jurisdictions that we have screened. Hong Kong, for instance, allows up to 36 months, 3 years. And then obviously the target would need to be onshore, offshore, and then the exchange, the ATX in this particular respect would need to be notified of this SPAC proposed transaction long before the deadline of 24 months is actually being exhausted. Obviously, the target entity can be in a variety of sectors, but what we have seen so far is that tech entities or pharma entities or in general industries that are capital intensive tend to be preferred for the SPAC transaction. And then once a target is being identified, right, the regulators impose certain conditions for this target. So one may not believe that any kind of, let's say, limited liability company can be can go public through this kind of this SPAC transaction or through this kind of merger. Basically, the fair market value of this initial acquisition needs to be of at least 80% of the gross amount held in escrow by the respective SPAC. The specialists in the field say that it's not generally a problem to comply with this condition, noting that the targets that are being identifiable and usable in a SPAC transaction tend to have, let's say, a value which is generally 3 times higher than the amounts that are being kept in escrow, therefore meeting this condition that the fair market value would need to be much higher than the amounts held in escrow. And now moving forward on how the completion of this SPAC M&A transaction takes place, as said, because of the special regulation that appears in the SPAC spectrum, the rules of traditional M&A that are regulated in the commercial legislation, the commercial companies law with regards to public joint stock companies are being changed, right? So these would not be applicable in this particular case. The procedure that is being applied in UAE to SPAC transactions is actually as follows. The SCA receives a certain amount of information, detailed information, as to the proposed SPAC transaction, and then the shareholders that hold minimum 75% of the share capital of the SPAC would need to apply and approve this SPAC transaction in a general assembly meeting. Now, the shareholders that would not approve this kind of transaction will have the right to redeem the shares at the time where the General Assembly has determined to extend the time period for the SPAC to complete the SPAC transaction, and that particular shareholder would not agree or had voted against this extension, or at the time of the SPAC transaction. So the security that the regulators add to this kind of SPAC structures is that the shares that are being invested into by the shareholders, by the investors, are redeemable. However, this redemption is happening pro rata, and it's usually happening at the IPO value of these shares. Once this transaction, the SPAC transaction, is being successfully concluded and the new entity, the target, being merged into the newly formed entity, yeah, with this SPAC, then obviously the newly formed entity, as said, would not benefit from the rules under the SPAC regulations, under the SPAC framework, but it would become a simple and normal public joint stock company, subject to the provisions of the new commercial companies law. With this in mind, yeah, we have also observed, aside of these procedural elements that would need to be considered in incorporating and operating this kind of vehicle, we have observed that, let's say, in markets that where these SPACs are traditionally used, and I would say the US in this particular case, post 2020, litigation involving SPACs is on the rise. Obviously, the USA is the type of jurisdiction that allows class actions, which is not the case in the UAE per se. However, in order to avoid this kind of, of negative elements, it is obvious that the proper due diligence would need to be concluded, that certain elements would need to be, let's say, paid attention to as we would see right away. As said, in UAE, it is the case that both professional investors and retail investors would be offered shares and warrants in SPAC transactions. For professional investors, it is always the case, but as said, it would remain to be seen when and how these SPAC transactions are going to be open to retail investors. Then farther on, obviously, it is to be known that for any investor who wishes to go ahead with this kind of structure, the shares and warrants would need to be paid at the time of subscription upfront. Now, for these key takeaways, as we were saying, the litigation is on the rise since 2021. We would also advise our clients, and obviously this is a generally known variable that probably lawyers that operate cross-border transactions would take into consideration. It's a huge difference in between a SPAC transaction that operates within one jurisdiction and a SPAC transaction that operates in multiple jurisdictions. Aside of the time element that is grossly varying from one jurisdiction to the other, the requirements related to listing, to the price of a share, to, let's say, the prospectus, the way in which, let's say, various stock exchanges work, need to be carefully considered prior to making such an investment. And then, obviously, due diligence is a must, we would say. And as a very simple advice, a client would need to be informed that, yeah, the prospectus of an IPO would offer important information as to what to expect, as to who are the sponsors of a specific SPAC, which obviously the investor would need to rely on in completing this SPAC transaction and valuing their investment. And further on, it is known and it is tested, I would say, that taking a company public by merging it with a SPAC is a faster and cheaper process in comparison to the traditional IPO, and then obviously exposes the target to less volatility than a traditional IPO for the reasons that we have stated earlier. Yeah. So we would say that the process of, let's say, issuing a traditional IPO involves third-party regulators. It's a highly regulated process. It may include an investment bank. It may include a valuation where, let's say, the company at issue may not be directly involved. There are several third-party factors that the entity at issue may not control. It is not once that during IPO processes, certain irregularities have been disclosed to the general public that literally affected not only the value of the transaction, but also the possibility, let's say, of the investors of redeeming their shares or valuing them post this respective company being public. And from the examples that we have given earlier, yeah, it is shown that actually SPAC may raise more capital, 10 to 15% more than a traditional IPO. Therefore, from a business perspective, the benefits are significant. However, from the operational perspective, it requires, obviously, compliance with the rules, compliance with the mandatory appointments, but last but not least, a lot of knowledge on the part of the people who operate this kind of structures. These structures being new into the UAE, we have addressed this webinar in order to shed some light for both PE practitioners, capital markets practitioners, but also corporate lawyers at large who may come across this kind of structures in order for them to understand how things work, what to expect, how much regulation is in place. And we can see from what we have discussed so far that the regulation is not small, that the SCA took their measures from the beginning of the year, from the moment that the law entered into force, in order to actually address this kind of structure, and in order to streamline, let's say, a certain volume of investments that are rooted in UAE and through UAE. Further, we have synthesized in here the process on how an investor may look into these SPAC structures and their investments. So basically, we have an IPO where the investor places funds into the SPAC. SPAC places the funds in escrow. Then post IPO, the SPAC has the 24 months time frame in order to identify the target. This target or this acquisition merger with the target is submitted to the vote of the shareholders, and as said, the minimum 75% threshold needs to be met. And then there are two solutions possible. Number one is the approval of the transaction, case in which this SPAC transaction is being completed. The shareholders of the SPAC would become involved, would become participants in this newly formed entity, and would benefit from the development or decrease of the value of shares in this particular newly formed entity. Or they also have the possibility to redeem their shares at the time of the SPAC transaction is being, let's say, completed, or if, let's say, provided that certain extension for this acquisition, for this M&A transaction has been approved, but that particular shareholder is not in agreement with it, then they also have the possibility to redeem their shares. In the second scenario, if, let's say, the shareholders vote is not in favor of a specific M&A transaction, of a specific SPAC transaction, then that particular SPAC will enter into liquidation, and post liquidation, their shareholders are going to be repaid their investment pro rata, as said, at the IPO value, provided that the funds are available in escrow, and they should be available in escrow. We were checking the other day the website of the SCA, and we came to know that there are a series of fines that are being issued on various heads: compliance, AML, non-regular procedures in various, let's say, regulated entities, not necessarily SPACs. Regulated entities at large. Obviously, we would need to know that for as long as the entity subsists in the UAE jurisdiction, the compliance requirements that are particularly derived from the substantive law of the United Arab Emirates would need to apply. And then we would cope with the mandatory appointments, AML standards, KYC requirements, designated non-financial businesses, etc., or whatever would be applicable at the time of using this kind of structure. And then, as said, post this SPAC transaction being completed successfully and the target being acquired, incorporated in this new structure, the target would go public as a joint stock company, as a public joint stock company, with the only difference that this new joint stock company, this new public joint stock company, would be regulated by the Commercial Companies Law and would cease to exist as SPAC, benefiting from the SCA requirement. As an interim conclusion, to this section, we have tried to explain the full procedure behind operating a SPAC and which are the requirements of using these SPACs in the UAE and what can they be used for in UAE. In order to benefit to the corporate community at large, and knowing that post this SPAC, this company becomes a public joint stock company per se, we would definitely need to look into how the commercial companies law looks into the regular, normal joint stock companies which are not SPACs. We know that joint stock companies, and in particular the public joint stock companies, have a specific type of regulation in the commercial companies law. The lawyers who do not work with joint stock companies may, let's say, be interested to know more what kind of, let's say, regulation applies there too. But in order to respond to this new requirement for, let's say, streamlining more capital into the UAE or through the UAE, for creating treasury centers to the due to the more approachable taxation regime that exists in here, there are other support provisions that transpire throughout the commercial companies law. And in this particular respect, we would need to highlight here some of the most important ones that apply to the public joint stock companies per se. Nationality of board members under Article 151 from the law has changed. Prior to this new law entering into force, the nationality of the board members was reserved for UAE nationals. Things have changed because as we see from the verbiage of this article, the requirements are now determined by the Council of Ministers in accordance with the provisions of Article 10 of this decree law. Now, if we look into the Article 10 of this decree law, it determines the activities of strategic impact in the UAE economy, whereby, let's say, even 100% ownership held by a foreign investor is now allowed in specific designated criteria as approved by the Departments of Economic Development in various emirates. So therefore, for joint stock companies, this requirement of the board of directors has been changed in order to allow this penetration of, let's say, skilled professionals that would possibly be retained in the jurisdiction, that would possibly, let's say, qualify as mentors for institutional investors, for sovereign funds, etc., in order to, let's say, lead toward a more, let's say, approachable and a more uniform, a more predictable capital market in the UAE and in the region. Obviously, we have other changes that have been introduced with regards to the public joint stock companies, and I would look into Article 162 towards liability of the board of directors. So the new law is saying that the company chairman, board members, or members of this executive management would be ipso jure released from service at the time that the court ruling is issued against them for concluding deals or transactions that involve conflict of interest or via other violations of this particular law. Now, if we look into what is happening in other jurisdictions, even with regards to SPACs, the background, reputation, knowledge, experience of a SPAC sponsor is the essential condition for the success of that particular transaction. This condition now transpires overall the legislation within the realm of public joint stock companies that benefit from the same kind of provisions, which is quite normal provided that these entities acquire and hold public marketed funds, right? For this particular reason, you see here in the commercial companies law a set of more robust, more muscular proceedings when it comes to lawsuits against, let's say, related parties and direct proceedings that now can be started against, let's say, company member for specific damages. And probably the most important or the most attractive for a business professional provision that exists now in the commercial companies law is the possibility that a joint stock company is being divided both horizontally and vertically under the overall guidance and approval of the SCA. Therefore, these structures have become, let's say, more flexible. For this reason, you have a series of Spvs and investment vehicles that have been now regulated in order to allow this kind of division and separate a set of liabilities, assets there too. We can, upon a cursory review of this new law, look into how, let's say, other provisions have changed in relation to the SCA, to the public joint stock companies. Subscription has changed. Nowadays, the initial provision that the funders would need to subscribe to a minimum 30 and maximum 70% of the issued share capital of a public joint stock company has been changed in order to allow these founders to contribute according to a prospectus that is issued in line with the SCA approvals and directions. And one of these approvals and directions that may actually differ from the traditional model of a joint stock company is actually the SPAC that we've been discussing before. Remuneration of directors has changed. It's now a statutory provision that bonuses cannot exceed 10% of the company profits. And then obviously under an approval of the General Assembly, a director can obtain a lump sum annual fee of not more than 200,000 dirhams as remuneration. These provisions also support the criteria of reputation, of log standing, of, let's say, lack of conflict in order to make the market more predictable and more appealing. The General Assembly meetings rules have changed. The same has been changed throughout the commercial company, new CCL, the new commercial companies law. We were discussing in the beginning of this discussion that everything has changed with relation to LLCs. Now things have changed in relation to public joint stock. Nowadays, these General Assembly meetings being convoked on a 21 days notice, unless shareholders holding not less than 95% of the capital approve another date that can be shorter. Quite important, the discounted shares. This was not in the previous version of the CCL. However, public joint stock companies now in the possibility to issue discounted shares subject to specific resolutions and under the scrutiny of the SDA. And then obviously the nominal value of shares has been also changed because nowadays this can be freely determined, unlike the previous law, which was setting a range of 1 to 100 dirhams per share. So quite a number of changes. So now moving on to the closure of our discussion for today, it was our pleasure to present these legislative changes and the opportunities that have been created by them for both the business community, but for the legal industry as such. Us as lawyers, we definitely have new areas of practice, new areas where we can work with, let's say, professional investors, institutional investors, etc., where we can offer to our, let's say, clients coming from different jurisdictions new investment vehicles and new forms of let's say, placing funds and growing into the UAE as a market. And last but not least, obviously, we would need to look into the larger purpose of this regulation to make the UAE a more attractive business hub. These changes, as I said, came at the time of a general overhaul into the legal system in here, and not only in here, in other jurisdictions that do act as business hubs and usually attract a large number of investments. Now, if we look into the UAE, it does have a strategic position, and it does provide a series of advantages, not only taxation-wise, but then if we look, for example, by comparison to the common market in the European Union, SPACs as an investment vehicle would be very difficult to harmonize due to the differences in the positive norms that exist in various jurisdictions in the EU in their 28 member states. So we deem this opportunity created by the legislation as extraordinary, as welcome. And we do look forward to advise our clients there too. And we hope that this particular discussion was useful for other professionals in doing the same thing. I'd like to thank you once again. And with this, I give the floor to Magdalene.
Thank you, Dr. Laura, for the very insightful presentation and for simplifying the subject for the benefit of all the attendees. We have now reached the Q&A segment of our webinar, and I can see that there are quite a few questions coming in. What we will do is I will present the questions to Dr. Laura, and we will attempt to respond as many of your queries that we possibly can within the Q&A segment. Dr. Laura, the first question that we have is, what is the difference between a traditional IPO and a SPAC transaction? Why does the SPAC have more advantages?
Thank you for the question. I don't know if it has more advantages, but business-wise, the SPAC is, let's say, an easier way to go in public. So let's put ourselves in the mind of a company that wishes to go public and to have access to larger amounts of capital, I would say, and to more visibility in the market, therefore to more market share. So in order for somebody to go public, that company needs to be first of all valued. The valuation is done by obviously a third party, to which me as a company willing to go public, I probably do not have access to, or I'm not able to influence the process, or maybe I have several skeletons in my closet that I do not wish to discuss, to disclose to the general public, etc. It's very normal in business, and this aspect is not to be hidden or overseen, whatever happens. Moving forward, an investment bank would need to be involved. Me to go public as a company involves a lot of regulation. So it's a lot of scrutiny on the part of a regulation, of a regulator. And finally, it involves a duration. So we've seen cases of companies that manage to go public in months and in years. It's not always a rule. The larger the company is, the more difficult it is to go public. So all this process for going public represents a hurdle. It's not an easy process. It can be successful, but it's not an easy process. So in order to avoid this kind of process, which, as said in the discussion, exposes the target company quite a lot to certain variables that they cannot control, as well as to macroeconomic factors that come from the market, this SPAC is a structure that has been created in order to avoid all these hurdles. So when the sponsors create this SPAC, the SPAC goes already public, without knowing who is the target. It goes public. The entity is fresh, is scrutinized by a financial regulator. It provides certain guarantees to the investors, and post IPO, post the funds being acquired from the market and being held in the escrow account. Only after that, the SPAC would start the discussions with the said target. And then this is done within the spectrum of, let's say, 2 years, as we've seen in the presentation in the UAE. So this makes things very easy for the target, because the target is less exposed to this hurdle and has the ability to directly negotiate with the SPAC the terms of this merger, which is not happening when the target goes public by itself. So when you negotiate directly with the SPAC the conditions of this merger, obviously the target is in an advantage, and the regulators are happy because the IPO and the regulation has been met by the SPAC already. Therefore, it's much easier to introduce and complete the SPAC transaction, allow the target to go public, allow the target to list shares on the respective stock exchange, and therefore it's more or less of a win-win situation if everything goes well. So I would say that from a business perspective, it does have certain advantages, and it's a more simple process, a more predictable process to go public in comparison with a traditional IPO. So I hope that I managed to respond to our participant who asked this question. Thank you.
Thank you, Dr. Laura, for that difference between an IPO and the SPAC. The next question that we have is, which are the main ways in which a SPAC transaction is more secure than non-regulated investment?
Oh, that's quite a good question. I would start, let's say, this comparison with the non-regulated entity. Any corporate lawyer is coming across a client that, look, I have this structure, I want to put money in this company and from this company in this company, and I want to bring investors and. Obviously, this kind of structures happen at the lower scale. We discuss about 2, 3, 4, 10 investors, and most of these companies are not non-regulated. Obviously, when you are in a non-regulated sector, your ability to attract large funds or credibility or solvability in front of a bank is very limited. Also in front of a contractual partner, very limited, because whomever wishes to invest, or any venture capitalist who wishes to invest in an entity, needs to have a guarantee of their return of their investment in equity or in any other, let's say, kind of consideration which is lawful. When we discuss about SPAC, we discuss about the different levels. We discuss the bigger money. We discuss about, let's say, the ability to gather together a number of investors, hundreds, thousands. So we discuss about the big money. At that point, the regulation and the scrutiny that is being given to this kind of structure is paramount. It's actually necessary. So therefore, in comparison to a normal SPV, to a non-regulated SPV, the comparison doesn't even, let's say, make sense, because we discuss about two different levels of investment. And we would see that the growth of the litigation that we have seen in this field in the past few years happens because of wrong investments in non-regulated SPVs. There's nothing stopping, let's say, an investor that has some funds available to invest professionally through an SPAC, subject to obviously meeting these requirements. So in the end, we discuss about two different, let's say, business sectors and two different levels of doing business. Obviously, when we discuss about funds that are being applied from the public market, obviously the regulator needs to come in counterparty and to balance the power that these sponsors have over these funds and the way in which these funds are being actually disbursed. We've seen there is strict regulation in UAE and everywhere as to the level of the promote of what, let's say, these sponsors can get out of the SPAC transaction. So for this reason, we would say that it's much more secure to invest through public joint stock entities. However, it may require a level of, let's say, skill or a qualification criteria, or working with an institutional investment company, etc. So I would say that the differences mostly appear in this field, in this region.
Thank you, Dr. Laura, for that distinction between regulated and non-regulated investment generally. The third question that we have here is, are cross-border transactions more complicated than national transactions in capital markets? And if yes, what aspects do investors need to be aware of?
Yeah, cross-border transactions, I'd say they are more complicated. For any lawyer who had contact with the cross-border M&A, they know that we discuss about, let's say, regulators from different jurisdictions, transfers of shares in different registries. This adds, first of all, a duration. But when it comes to SPAC transactions, I would say that it's much more difficult to do due diligence on a target which is situated in a jurisdiction that you don't know. Not impossible, but it's more difficult. The rules of listing or the various rules of, let's say, placing funds in a cross-border SPAC transaction can be more difficult, more time-consuming. And I would say that in these situations, that an investors always depend on professional advice from consultants, from lawyers. And obviously, it may be longer that this SPAC transaction to be actually completed. It may take longer that the shares are being valued or redeemed by the investors. So yeah, it is a difference, and cross-border elements make these transactions a little bit more complicated. Hopefully, with the introduction of the blockchain technology in the close future, these drawbacks would be somehow diminished or eliminated. I would say I'm more positive in this side, and yeah, hence I think that with this I hope I have responded to your question.
Thank you, Dr. Laura. The next question that we have is, how can an investor receive his money back from a SPAC transaction?
This is a quite simple question. Basically, the investor puts in the money at the time of IPO, subscription, shares or warrants, whatever available in that particular IPO prospectus. And then normally there are two ways under which this investor receives the money back: at the time of the de-SPAC transaction, or in case, for example, a specific de-SPAC transaction has been voted, the shareholders in UAE with a majority of 75% have agreed on a specific extension, and the investor at issue is not in agreement with that. These are the classical ways in which this investor can redeem their, let's say, shares. There's a third way, which is litigation in case something goes wrong. Hopefully not. But as said, we've seen litigation on the rise, and we are not excluding this possibility as well. Litigation means that it's a case of default somewhere, it's a problem somewhere, so the matter needs to be litigated, therefore the shares or the value of the shares to be awarded by a competent court.
Thank you, Dr. Laura. The next question that we have is, aside of IPO, does the SPAC structure allow private placement of funds? And would you advise this to your clients?
In UAE, if we look into that, that's quite a good question, because professional investors always look into that. So yeah, it's quite a good question. In UAE, it is mentioned specifically that the private placements are allowed, and also the money that are being held in escrow at the time of the IPO can be reinvested in, let's say, interest or non-interest bearing accounts, as the case may be. The framework that we have in UAE does not mention specifically the term of, let's say, of liquidity or liquid investment. However, yeah, it's possible to place money in private placement, and subject to the approval of the shareholders, excepting the sponsors. So this is a possibility, yes.
Thank you. We have yet another question that is, does compulsory acquisition as per the SCA rules on mergers and acquisitions apply to SPAC transactions?
No, for as long as it's a good question. For as long as the SPAC enters into the SPAC transaction under this regulated domain of the SCA in UAE, obviously compulsory acquisitions would not be because applicable, provided that the entity is exempt for certain provisions of statutory formation. But yeah, it's quite a good question. I believe that this question comes from a participant that is well accustomed with the capital markets in other jurisdictions, because compulsory acquisitions originate as well in other jurisdictions. Yeah, but thank you for the question.
Thank you, Dr. Laura. We also have another more practical question on the new structures. That is, are you aware of any SPAC application made yet under the new regime, or even the IPO being completed?
SPAC application made to the SCA, you mean?
Yes, I mean that's specifically not specified in the question, but whether you're aware of any such transaction having taken place.
Particularly the time, I think, is very short to have, let's say, knowledge of this. I wouldn't give a name. However, I'm seeing a lot of IPOs being issued recently. You come across a lot of newspapers ads and ads in various online environments. So it's possible that this may be as a result of a SPAC IPO. Yeah, but me personally, to give a name, I would not be aware of that in the jurisdiction.
Thank you, Dr. Lola. The next question that we have is, under the new CCL, is the SPV looked at as simple non-regulated entity?
That's a question that I have received before from a variety of clients. SPV in general is a quite wide term. You have SPVs everywhere. If you look into, let's say, ADGM, you have a series of SPVs. You have a series of exempt companies. If you look in, for example, any free zone structure, you have a series of holding structures, of licensing regimes that are basically innumerable. Now, stricto sensu per se, an entity can be used as an SPV, but it depends for what. Now, in the realm of the law, the term SPV is strictly regulated because it looks into the possibility of that entity, of that SPV, to acquire larger amounts of capital from a variety of investors. And that is why these SPVs operate under the realm of a regulator. For example, SCA for the mainland UAE and for a number of the free zones, except in the financial free zone. So when we discuss SPV under the new commercial companies law, obviously we mean the regulated domain and the purposes for which these SPVs are actually used. As said, now there's a real possibility recognized in the law to divide public joint stock companies horizontally and vertically as well. So when you create, let's say, several verticals of a joint stock company, obviously you need I would say the support vehicle in the law, yeah, as regulated entities in order to separate, to isolate liabilities, assets, or as the case may be. So I think this is what the participant wanted to have more clarity on. So I hope this is the right answer.
Absolutely. Thank you, Dr. Laura. The next question that we have is more of a confirmation of whether the understanding in this case is correct. And the question is my understanding correct that the investor at the time of making the commitment or paying funds to the SPAC he or she has no idea what target company the SPAC may invest into.
That's true. That's true. That's why these SPACs are being called blank check companies. At the moment that the IPO, the investor subscribes to the prospectus, to this public offering. Then it has the investor has security over the funds because the funds are being placed in escrow, and then this particular SPAC post IPO, post listing, then would decide on this target. And there are actually SPACs, probably not in UAE because we don't have that much of precedent, but in other jurisdictions that were not able to identify a target. It's also a possibility. Of course, a smaller percentage, but it is a possibility. But as rightly said, at the moment that the investor subscribes to the IPO, they only rely on the expertise of the sponsors, on their experience in leading this transaction in the future to a successful de-SPAC thing, but without knowing at the time of subscription in what they would be investing further. So that's true.
Thank you for that clarification. The next question is, do you emphasize any drawbacks of the recently regulated structures under the new commercial companies law?
Drawback, perfect regulation doesn't exist anywhere. So any law operates with a specific degree of generality. Now, drawbacks, I would say that it depends on how, let's say, reliable the approval process is. And I don't think reliable is a good term. How fast things are moving for a SPAC application from the, let's say, Ministry of Economy affiliated structures, for the SDA. How stringent are the controls? How much security the regulators impose over the funds, aside of, let's say, the provisions that appear in the law? So I would say that there are a lot of variables to consider, but what we see from the investors that come from abroad on various other structures, they wish the things to be done fast. They wish things to be done, let's say, in a manner that allows them to operate as soon as possible. So obviously this puts pressure on the response time of a regulator. But we do hope that in UAE, which is, let's say, capital intensive when it comes to technology, this medium to be used in order to shorten the procedural times and the approval processes in order to, let's say, make the jurisdiction even more attractive to qualified investors, to normal investors coming from other jurisdictions.
Thank you. We have just two more questions. And one I think is something you've briefly touched upon in your presentation, that is, how can a joint stock company divide using these newly regulated structures?
Okay. Simply put, a joint stock company divides as any other company. Yeah, simply put. So it's very normal for a group of companies to have subsidiaries, to have divisions that, let's say, outsource one from the other. It's quite normal. The same, let's say, process would apply in a joint stock. For example, when we look into a multinational, it has a specific number of horizontal divisions. For example, customer service is done by a subsidiary in X market. Customer support is done from a subsidiary in other market. Marketing can be done through a branch in another jurisdiction, etc. These would be examples of horizontal divisions. Joint stock companies can also have this kind of division, however, provided that they act in a more regulated, let's say, domain in comparison to a commercial company. They need the support structures that are also regulated, because you can't take money from, let's say, a joint stock company and place them in an LLC just like that. It would be easier to do so when you move it from an LLC to an LLC. That's something where we understand. But in here, the financial regulators, respectively the SCA or whoever is the supervisory authority, needs to have a flow and needs to have a supervision over this transfers of funds, of liabilities, of assets. For this reason, the support structures needed to be created in the law, and that is why you have these SPVs or the entities that do exist in order to make this division possible, I would say. So overall, it's a very good development from the point of view of a legal professional.
Thank you, Dr. Laura. We'll take this as the last question, that is, can you let us know your belief with regard to the relaxation of measures under the new CCL overall? Do you deem these are made for opening investment only?
I sincerely do so. And we have seen these overhauls that happen in a variety of sectors. We see now a new regime for visas. We see new employment rules. We see a lot of new developments which are targeted at attracting investment and making the jurisdiction more, let's say, appealing for professionals and investors worldwide. And yeah, I do believe that there is this underlying target behind all these overhauls and all these changes, and we do welcome that.
Thank you, Dr. Laura, for answering these questions and for providing clarity on the functioning of SPVs and SPACs under the new Commercial Companies Law. It was truly an insightful session. We have now arrived at the end of our Q&A segment and of our webinar. I'd like to thank everyone present in this webinar for your support. We hope that the webinar did give you a deeper understanding of SPVs and SPACs within UAE. To stay updated with all our new webinars and articles, please follow us on LinkedIn and Twitter. Thank you, everyone.